Thank you, Sean. My name is Jeff Mullen. This is, it's November 22nd, 2021. This is a continued hearing in the matter of the comprehensive permit for 582 Blue Hill Avenue. With me are Frank O'Brien and Giselle Joffer, both members of the Board of Appeal. In the prior session, we discussed at some length the substance of the draft a decision that was prepared by Ms. Barrett. Thank you very much. Since then, well, following that hearing, or that session of the hearing, we had some suggestions, a markup for Ms. Barrett. I know she's been working on it. She's been interacting with members of the town. Tonight, we don't have a revision, but so I think this is going to be a short hearing. But I'd like for, certainly we could hear from Mr. Zawinski if he would like. But I'd like to hear from Ms. Barrett on the status of the draft and her estimate of when she might get that to us so that we can take a look at it for the purpose of finalizing this matter. I will say, and I think some of the board members were copied, I know there's been a fair bit of back and forth with town officials, including the building inspector and the DPW commissioner, Mr. Zawinski himself, regarding the roles and responsibilities of various members of the town government, which I think is an important part of the decision in terms of whether the matter is jurisdictional for the town engineer or the DPW director, et cetera. So I think that's important and time well served, but be that as it may, that's where we are.
It is what it is.
Ms. Barrett, do you have anything? So the members have any question about that?
No. We're just trying to straighten out what needs to be in the decision, what truly is kind of a departmental issue. When should we have something in the decision, even if it's a departmental issue, so that it's very clear to everybody who's doing what. I think one of the things I've been wrestling with a little bit is that I know the decision has a couple of references to money deposited with the town in case peer review consultants are needed for whatever reason during construction. There's a provision about surety being posted. And I think that I'm just trying to get some clarity about who's going to make that decision. If like the town department heads feel like they can handle the whole thing in-house, then I'm not sure the applicant needs to pay anything. But if they feel like they need the help, then I think we just need to give them cover. As for the surety thing, I think it's just making it clear that whatever we're asking them to do, needs to be consistent with what any other project would have to do and not more than that. And so I'm just trying to wrestle with the language on that, but I think a lot of the other stuff we've talked about is actually in pretty good shape. Tim has been kind of trying to work through the question of the language that needs to be in here about the bus stop, school bus stop, future T stop. How do we make sure there's no conflict? I'm not sure, and I don't want to take Tim's thunder. I know he's on and he may want to address this directly, but it may not be possible at this juncture to solve all that. I think what we need to do is just set up how the decision will be made at some point down the road by the parties responsible. And certainly, wherever the school bus stops, it has to be approved by the school department anyway. So I don't know kind of how we're going to fix that, but Tim has been trying to deal with that. And then what else? Actually, I think that may have been it, unless I'm forgetting something important to all of you.
Ms. Barrett, what's your timing on getting us a draft?
Thanksgiving's coming and nobody's going to call me. There won't be any phone ringing. There won't be any meetings I have to go to. I'm figuring I really should be able to wrap this up by the weekend. That's what I'm thinking.
Okay.
I mean, that's some of these little, certainly the body of the whole decision I can have done this weekend. Now that if there's still stuff to tweak about who's going to decide about the surety or who's going to decide about the technical review fees, that may take a bit more discussion on your part, but the rest of this really is just, there's a form of a decision. There's content that has to go into it. We need to kind of recap what happened at the hearings. There are the jurisdictional findings. There are the findings of fact and cleaning up this decision. And we're kind of close.
excuse me, was there a surety, was there a deposit? Or, or any request for a surety in the Ice House matter?
I believe that there was. That's a good question. I can answer that in just a minute. Yeah, it's wonderful that one of these is closed. My God. Hold on. Decision. Final. Here we go. I'll be able to tell you in a minute. Yeah, there it is. There it is. Just open up the Word file, would make it easier to find it, wouldn't it? Actually, you know what, Mr. Chair? No, it appears that there not have been.
Okay.
Yeah, it's not in here.
Well, the reason I ask is whatever we do, I'm mindful that it's going to, it will likely apply to the other cases. So I want to take the time to get it right.
It is there. It is there. It is there. It's in the what has to happen before the building permit can be issued. So it was to provide security in the form of a performance or payment bond, an amount equal to 25% of the cost of restorative landscaping. Funds will be used to restore the site if it's abandoned, et cetera. So that was in the Ice House decision, but not a specific dollar amount.
Yeah, and okay. And it wasn't mentioned who was going to do the holding, who was going to hold that?
No.
Okay, so we'll just leave that to the town. Okay. Mr. Zawinski, do you have anything you'd want to add at this time?
Yeah, I've spoken to a number of folks on each of the matters that you've brought up. I pulled out all of the relevant sections that mention either a security or a surety or a bond, and called those out for Mr. Berkeley. He's had a little bit of a hectic week and a half, so he's going to have some information for me tomorrow that I can pass along to the board and to Ms. Barrett. Just regarding, if that language is consistent with the department's practices on bonds and sureties. And if you all have questions about, exactly how that, what mechanism that takes, we can certainly get that for you, but I'll have some more clarity on that particular issue tomorrow. I did provide.
Just on that, Tim, just on that. I mean, just from my perspective, I would like it to follow the standard town practice, so we don't kind of have parallel government here. Like we don't have, what I don't want to do is build like the separate 40B way. Whatever the way that the town does these kinds of things, we ought to follow that, unless there's a real compelling reason to not do that. I mean, at the end of the day, this is a permit being issued by the Board of Appeals. It just happens to be being issued under Chapter 40B. So I'd like to leverage the town processes as much as possible.
Mm-hmm.
I think that is, oops, sorry, Mr. Bryan.
Thank you. Sorry, Tim. We should take a look at the town language, and I wholeheartedly agree with you that we should utilize the town language and not reinvent the wheel. However, I just want to make sure, coming from the insurance side, that the language is okay. Sometimes this stuff, it hangs around for a long time. People don't look at it and it doesn't get updated. So I'm not saying that that is a problem. I just think the board, particularly me, I'd like to take a look at it before we move ahead with it, just to make sure it's okay.
That's why Mr. Leonard put you on this panel, Frank. That's the main reason. Pretty sure.
I thought it was because I was good looking, Mr. Chairman.
That too. I'm sorry, that's the second reason. Good looking is the first.
Sorry, Tim.
No, not a problem. So Chase is going to take a look at that language, and if he's got any tweaks or suggestions, he's obviously very interested in doing things the way that we typically do things. The question that I had, well, let me get into some other stuff. I did provide Judy with some language just regarding consistency of the plans with the future Route 138 improvements. It's tough to say. It's at a very schematic design phase right now, that plan. So the language, and you all will see it in the next draft, just kind of references, consistent, don't preclude anything that the Commonwealth is trying to do. We can wordsmith that if we need to. On the issue of the bus stop.
Tim, on that's not intended to be a high barrier. You want to be designing this anticipating that 138 improvements are coming, including a shared use path at some point.
Right.
Yeah.
We recognize there's no design drawings and et cetera, but you just want to be anticipating that in the design so that it can easily be modified.
Yeah, no, absolutely. And I think if the language doesn't already do that, it should be a pretty easy fix to make it that way. Judy mentioned earlier about the bus stop. I know you asked me to put a little thought into that, and there's no sidewalk on this side of Blue Hill Ave, so the applicant will be building a stretch of sidewalk to accommodate children kind of going out and catching the bus. It's as Judy mentioned, it's tough to say whether or not that'll be consistent with or in conflict with or anything with any kind of future MBTA bus service. There is no kind of fixed bus service right now. There's no sidewalks. If they decided to run fixed service, it would need to, the stop would need to be at the sidewalk that the applicant built, because otherwise there's nowhere to stand. So it's kind of, we're just going to have to keep our eye on it. I don't know if there's a way to codify. We'll keep our eye on it. But I think that's kind of where we are on that. And as Judy said, we've got a pretty good idea of where that bus stop, is going to be and should be. The school department, once we get to, more worked up designs as this project moves along, we'll want to have some input on the actual mechanics of how that's going to work.
I think it's fair to give, I think it should be designed to accommodate a school bus and should be designed with the anticipation that it might host an MBTA bus stop at some point in the future. Excuse me. But what I want to avoid, and I think we should avoid, is having a situation where, but for the fact that the stop got designed in a way that precluded the T from stopping there, the T would stop there. I mean, this is all about incremental progress. So I don't want to lose that opportunity. We have asked for the developer to make every effort, or reasonable efforts, to speak with the MBTA about turning that flag stop route into a fixed bus stop.
Yeah.
With the idea that will help us to drive mode share. Now, I know we can't commit to the T, and they've got a whole nother better bus program and all kinds of things, but we just don't want to do things to get in the way,
Mm-hmm.
So I that might be a little bit tricky, but the developer has exhibited a willingness to work with us on these kinds of issues. So I want to make sure we've got some language in there. And then, at least from my perspective, I'm happy to leave it to the town officials to work to affect that, since I know that that's a shared goal.
Yeah, no, I think that makes a lot of sense. And so let me give that a little bit more thought. And then, the next time we meet with a fresh draft, I think we can all maybe take a look at that together. As it relates to, I did have a meeting with Joe Prondak, the building commissioner, about Judy's draft conditions. He had a few notes that I provided to Judy and to the board. I think as it relates, this relates, Mr. Mullen, to your question earlier about, what are the different town responsibilities? What does building department do? What does DPW do? Joe did write an email earlier today that went to you, myself, and Judy. I don't know if it went to the rest of the board members. We can obviously send that along. Just kind of articulating his position. And I actually talked to him at the end of the day today, just so I was clear on what his thought process is. His position is that if it's covered elsewhere, either in the fire code or the building code or whatever, it doesn't need to be in the comprehensive permit. And where he's coming from there is very, very simply, he deals with lengthy permits on a daily basis, and he's just, let's make it easier for people to read these things. And if it's covered somewhere else, it doesn't need to be in there. I think there's another way of looking at the permit in that it's a public document. It's a statement on a project. There's no harm in kind of reiterating different, aspects of other codes that are going to be followed, by this project. So, there's a balance that I think the board needs to, needs to kind of figure out for itself. As it relates to, jurisdictional responsibilities, the way that we've done it is, Joe knows what his jurisdiction is. And so when he reviews, the conditions, he says, this is me, this is me, this is me. And if it's not him, he is not a shrinking violet when it comes to putting things on the right plate. So, he made some edits about the planning department, and its relationship with mass housing, and DPW and its relationship with, other infrastructure aspects of the project. So I think, on this permit with Joe's notes, I think you should be in good shape in terms of, who needs to see what, because he has a really good bead on that. I think a rule of thumb that he would say is, if it's building code, it's him. If it's not, it's not. Now the building code covers a lot of different things that maybe you wouldn't expect. But I think that's kind of, the line that he draws. So on this particular permit, I don't know. I mean, obviously, if the board has questions or wants to know a little bit more or wants to clarify things, we can obviously bring that to all the relevant folks. But I think we're in good shape in terms of, what documents go to which department. Between myself, Joe, and DPW, I think Joe's done a pretty good job of kind of dividing those up and making sure they go in the right places.
With respect to the second matter, I agree with you. I think that's first of all, I think that's important, and secondly, I think you've got a good handle on that. So, Judy, if you could address that in the draft that you produced. As to the first point, I actually think it's important to mention that the project is subject to the state building code and the comprehensive fire safety code. And the reason is I think there's a fair bit of confusion as to what 40B waives and what it doesn't waive. We're really only talking about local bylaws here that are being waived, and that the board is varying those to the subject to the conditions in the permit. There's been a lot of testimony about whether or not the state laws that the town administers, such as the Wetlands Protection Act or the state building code, are being waived, and they're not. I think we should be clear about that, just for the record. I don't think there's any confusion on the part of the applicant, who certainly understands 40B, and the experts that have testified. But for the record, and for the ages, I think it should be noted in some form rather than just wholesale take those out. It is so subject.
Mr. Chairman, I agree with you. Someone in town government or a citizen should be able to take a look at the four corners of this document and figure out what has been waived, what is not waived, and where to be able to go for things. I do agree that if a subject matter is handled in another area, such as the building code or the fire code, referencing the building code or the fire code in general may be appropriate, because that directs the town official or the citizen to that particular area. I don't think it's a good idea to repeat wholesale provisions of those, because mistakes happen. And if a mistake happens, it's going to be the code and not the decision that's going to govern. So to the extent that we can avoid unintended mistakes or what have you, that would be a good thing. So I'm completely in agreement with you in terms of particularly the building code and fire code stuff.
Yeah, I think that all makes a lot of sense. And I just wanted to convey that, Joe has kind of made a stance clear. I don't think this is the end of the world for him. You're not slighting the building commissioner in a great way by kind of, he's just interested in decisions being as concise as possible.
Yeah, we know. He knows we have great respect for him.
Yeah, so I think we're fine on that, and I do tend to agree. That as a document that people are going to read with interest, I think it makes sense to kind of point them in the direction of what regulations are actually at play here. So that's all I've got for now. If there's additional questions that the board has, I'm always available. So just let me know.
Let me ask the members if they've got any questions.
Nothing further from me, Mr. Chairman.
Questions for Tim or just in general?
You have the floor.
So I have two questions. One is, how much time do we have left?
We have till December 6th.
Very good. Yes, I did check that after we spoke.
Okay.
I think if we needed a couple of days, Giselle, the applicant would agree to a modest extension. I mean, not a month of December, but a couple of days if we need it.
And then my second question is, to my recollection, I thought we hadn't completed our detailed and shared review last meeting. So although the edits haven't been made, do we plan to continue that this evening?
Oh, if we can, I thought we did get through it.
I sort of did too. And we had a bunch of notes.
Happy to do it if you think we need to.
I think we got through the conditions. I think, Ms. Joffrey, are you referring perhaps to the waivers?
Well, it's a little challenging for me because I don't have the document, but I just remembered that we hadn't completed it, but called it because of time.
There are some attachments to the conditions, but I think in some respects, the attachments follow the language of the conditions. So I guess what I was thinking is when we get through the conditions, we put the front end of this on there, and then we come back and we finalize the rest of the exhibits, which don't amount to a lot because what the board has agreed to do is, except in a couple of instances, has agreed to the waivers that have been requested.
Okay. And then finally, Judy, when we get the next version, will it be redlined? And if so, to which version?
So when we met last time, I had it kind of open and I was taking notes, and confessionally, as I've been going through this, I've been deleting as much red line as I can because it's just making me dizzy. It's making a mess out of the decision. So there are some notes that are in here still, which I'm going to keep because I may need some clarification from you folks, but I'm trying to make this not so much of a mess. It was just red line everywhere. And, the outline numbering had fallen apart because things were getting moved in different indentations. It was just a disaster. So I think what I'd like to send you next time is as clean a possible a version with some questions still in it or comments from me to the board still in there.
And are you able to, I probably can do so myself, run a comparison to the last publicly posted document?
I should be able to. I could just do that in Word.
Yeah, that would be
Like open
helpful.
two documents and do a comparison.
That would
Yeah,
be-
that would actually be easier, Giselle, than, because I really have been trying to clean up the red line as I go along. It just, I'm sure that the attorneys love red line, but frankly, I absolutely despise it. And it's just making a mess out of the document. So any of it that I could get rid of, I've just been doing it.
Yeah, I think my question is prompted just by my goal of, frankly, trying to remember a lot of the edits and what we wanted, because with the time gaps, it's just not that easy. But I think the comparison solves the issue. Thank you.
Yeah, that's a good point.
Okay, thank you. So I feel like, this meeting hasn't been as productive as we had hoped, I think probably when we said it, but it is what it is. And I feel like it's appropriate to ask Ms. Barrett to get this document to us as soon as she can, so that we can take a look at it, because we are marked for a hearing a week from Wednesday. And I do think, Judy, I think you should talk to the applicant. We are going to need more time.
I'm sure.
It's not for the lack of trying. But, so long as we make steady progress, I feel fine about that. But I don't see us I mean, if we had the document tonight, I might feel differently, but I feel like if we get it over the weekend or at the end of the weekend, it's gonna be hard to turn this in a final form for Wednesday, you know?
I forgot. I was trying to think about, didn't we agree to have a meeting at 5 o'clock? And I couldn't remember what day it was, but I'm just seeing it in my calendar now. It's next Wednesday.
Next Wednesday, yeah.
Thank you.
Okay, are there any other matters that the members would like to speak to?
I have a sort of a scheduling question. So, assuming Ms. Barrett can get us something by the end of the weekend, like Sunday, is there a date by which we should get comments back to her? And are we expecting another clean version? Or are we going into the next meeting with our comments?
I think we're gonna have to do the latter realistically, don't you think? You know?
Yeah.
I mean, I offered, the last time I saw a draft, I did offer the markup. And I think that might have been helpful. But I think we might just have to walk through it, Giselle,
Okay,
you know?
that's
I
fine with
mean,
me.
I think either it would be fine, you know, to save people's time, but I feel like if you don't get the document till Sunday, you might not have enough time to turn it back by Wednesday. I don't know, so maybe we'll leave it to the members' calendars to see what they're able to do within that period of time.
Okay.
Does that sound reasonable?
It does, thank you.
Chairman, just for planning purposes, I am going to be on the West Coast from Monday, the 13th, not arriving back into the Boston area until Thursday, the 16th. So to the extent that we can avoid, I guess I could do if we are coming up against it, I guess I could do a virtual meeting from out there if need be, but we prefer not to.
Okay. Okay, let's do our best to get it resolved.
Are we gonna, am I on? I don't know. Oh, yeah. Are we gonna date it for the next hearing for December 1st?
Yes, at 5 o'clock.
Oh,
Yeah, because I have a public hearing that night in Bridgewater.
so everyone's good with 5? I'm sorry, somebody else signed into our account earlier.
It's okay. I mean, I was surprised because I know this was supposed to be dedicated just for the ZBA, right?
That's why I reached out to Mike Dennehy.
Yeah, good.
We're gonna deal with it tomorrow.
Okay.
All right, this hearing is, this is further business for the board. This hearing is continued to 5 o'clock on December 1st.
Bye.
Thank you very much.
everybody.
Bye
Good
now.
evening.
Have a good evening.
Take care.
Bye.
Recording stopped.